May I please?
Yes.
My lord, I beg to mention item number 5. I am for respondent.
Yeah, Mr.
M. Wata, on appearing on behalf of K. Tasso.
Mr. So appearing on behalf of Mr. K. Tasso, Learned Counsel appearing for the respondent. 6. Adjournment of the matter.
My lord, kindly it may be taken up after 4 weeks.
6. Adjournment of the matter for 4 weeks. You are appearing the
I'm for the appellant also.
Mr. So appearing for the appellant doesn't have any objection. Prayer is allowed. Please the matter after 4 weeks.
Lordship, there is an interim order that may be.
The interim order so passed earlier is extended till the next week of listing.
Hi, Lord. Lordship, I beg to mention item number 19 on behalf of 19.
Yes.
On behalf of leading counsel J. Gini, counsel for the petitioner.
Mr. So-and-so, Learned Counsel appearing on behalf of Mr. J. Gini, the Learned Counsel appearing for the petitioner. 4
weeks.
4 weeks time. Have you taken consent of the other side? You write that with the consent of the consent of the counsel to the respondent. Praise for 4 weeks time. The prayer is allowed. List it after 4 weeks. 19 and 20. Same order.
May I please, madam? My lord, I beg to mention item number 17, madam.
Yes, you are appearing for?
I am for the appellant, my lord.
You are Mr.
N. Sora.
Mr. N. Sora, Learned Counsel, appearing for the appellant. Praise for adjournment of the matter for 2 weeks.
Lordship, may I humbly pray that this matter may be listed in next week, which date may be given and matter may be fixed for admission hearing. Lordship, here in fact they are challenging the Gavang decision and we are considering some it matter needs to be remanded back to the Vice Authority for fresh hearing. That's one. So Lordship, on next date, next week.
The matter may be Learned Counsel for the respondent. Learned Counsel for the respondent prays for listing of the matter
On 4th clause.
on 4th of September
In admission.
in admission column.
Yes.
My lord, there is interim order.
Let the matter be fixed or let the matter be listed on 4th in admission column. Interim order so passed earlier is extended till the next date.
All right. My lord, one more item. Item number 23, my lord. On behalf of DHGIM Kato, my lord.
On behalf of
DHGIM Kato. Here, STCGC, my lord.
SGC,
My lord, this matter appeal is pending before the Supreme Court, my lord.
so you need how much time? 4 weeks time.
Okay, ma'am.
Mr. So-and-so appearing on behalf of the Standing Council of CGC.
Yes, madam.
Standing Council of CGC and prays for adjournment of the matter as an SLP is pending before the Supreme Court. He seeks for 4 weeks time. Prayer is allowed. List it after 4 weeks.
Deeply obliged.
May I please, Lordship? Lordship, I beg to mention item number 22, criminal petition. In fact, Lordship, this is a joint petition for quashing of FIR and charge sheet. But Lordship, TCR has been called for, but yet not received. So Lordship, we humbly pray that reminder may be sent for the calling of TCR, and in the meantime, matter may be listed after 3 weeks.
Learned Counsel, Mr. So-and-so appears for on behalf of
Petitioners.
the so-and-so appears for the petitioner and he submits that PCR in this case is yet to be received.
Yes, yes.
Registry is directed to send a reminder for the TCR. Place this matter after 4 weeks.
Yes. In the meantime, Lordship, there is an interim.
The interim matter so passed earlier is extended till the next date.
We have license.
May it please Lord. Lordship, I beg to mention item number 24.
22 years.
Lordship, I am for the appellant. Lordship, herein Lordship, conducting counsel, Mr. Pangin is out of his station on
Mr.
emergency medical case. Lordship.
Mr. So-and-so appearing on behalf of Mr. B. Pandin, the leading counsel in the case of the appellant. He submits that Mr. Pandin is having some medical issues and he did not appear in the court. He plays for 4 weeks time.
After 2 weeks.
He plays for 2 weeks time. Prayer is allowed. Use the matter after 2 weeks.
Obliged.
May I, Lordship? Lordship, item number 4. I'm for the petitioner.
Item number 4.
Yes, sir.
You are appearing for
Petitioner T. Kamchi.
Mr. So-and-so appearing on behalf of Mr. T.T. Tara, the leading counsel in the case for the petitioner.
Major may be adjourned for 2 weeks.
He plays for 2 weeks time due to certain difficulties for Mr. Tara to appear in this case. This is matter after 2 weeks.
Interim order is there.
Implemented so passed earlier directed to be extended to the next date of listing.
Much obliged.
May I, my lord? My lord, I beg to mention item number 6, my lord.
Yes. What happened?
My lord, leading counsel is my lord out of station. Therefore, matter
So and so appearing.
appellant, my
Who-
lord. Appellant, my lord.
Who is the leading counsel?
You Deka.
Mr. So and so appearing on behalf of Mr. V. Decker, the leading counsel, the case, appearing on behalf of the appellant, right?
Yes, ma'am.
You are appearing also.
So-
Appellant. Citing, he is out of station,
Yes, ma'am.
stating that Mr. U. Decker is out of station. Prayer is allowed, please the matter after 2 weeks.
Oh, my lord, 1 week, ma'am.
2 weeks, 2 weeks. You've taken time, so 2
Alright.
weeks.
Again, one more matter, my lord. Item number 7, my lord.
Yes,
Same here, my lord.
same order, same order. Do that. Only thing is that appearing for the petitioner again.
My lord, there is an interim order, my lord.
Interim order so passed earlier is extended till the next date of listing.
Obliged.
Yeah, my lord, item number 8, my lord.
Item number 8.
Yes, my lord, I have been instructed by the council who is from Guwahati, Vedanto Kosik. The matter may be fixed after 2.
Who is the counsel?
Vedanto Kosik, my lord.
Mr. MS so appearing on behalf of Mr. Vedanta Kosik, the learned counsel appearing in the matter. She pays for adjournment of the matter for 2 weeks as Mr. Vedanta Kosik, who is an outstation counsel, will not be present in the court today. Prayer is allowed. Please this matter after 2 weeks.
My lord, there is an interim.
Interim order so passed earlier is extended till the next date of listing.
May I please, my lord? My lord, I beg to mention item number 20, my lord, on behalf of
20,
20.
item number 20. Yes, what happened?
My lord,
19 and 20 already mentioned.
my lord, there is an interim order in item number 20. It may be continued, my lord.
Item number 20, that interim order.
One more item, my lord. My lord, I beg to mention item number 15 as well.
15.
Yes, my lord.
Yes,
My lord, we have to file counter affidavit in this item.
you are MS?
M. Karbak,
You are appearing for?
appearing for
Respondent.
respondent number, yes, ma'am. Respondent number 1.
MS M. Karbak appearing on behalf of the respondent number 1,
Yes, ma'am.
and submits that she is required to file an affidavit in opposition
Yes, ma'am.
in the instant case. Therefore, she seeks for 2 weeks' time to file the affidavit in opposition. The prayer is allowed. Please this matter after 2 weeks.
Again.
Item number 1,
Yes.
May I please, my lord, here, bail application was rejected by the Lanet Special Court POCSO 0 twice. And the first bail application was rejected on the ground that 183 BNSX, that earlier 164 statement of the victim was not recorded. On that ground, first bail application are rejected. And subsequent bail application was filed subsequently. The Lanet Lanet Special Court POCSO, citing the ground that on second bail application that that first bail application was rejected and subsequent bail application was not citing any new ground. Therefore, if granted on bail also, it amounting to review their own order. Therefore, despite of IO not any made objection, despite of not any objection in the
So you
CD,
didn't have any phrase ground?
Yes. there is no such difference. Therefore, I approach before the Honorable Court.
So what is the phrase ground here?
Earlier application, the 183 BNSS, the victim statement was not recorded. Now that statement are recorded. So purpose of arrest was fully served because purpose of arrest is to record a statement.
Only that? Purpose of arrest is only recording of the statement.
Peer investigation of the case. So investigation is already completed. So further detention in the custody, no for any purpose.
Release the notice in this.
Yes. Only offense is molestation, section 8.
Heard Mr. So-and-so. Also heard. MS.
Lagi.
APP, learned APP for the respondents group. This is an application under section 483 of BNSS 2022 read with Article 21 of the Constitution of India from paying for release of the alleged release for the accused. It is filed by whom?
The web of the accused person, Toko Anetaj,
Filed by one Toko
Toko Anetaj,
Ano. Toko Ano.
Toko Anetaj.
Toko Anetaj for release of the accused Sri Taj Dhoni on bail, who is in judicial custody at Zero Jail in connection with Zero Omen Police Station case number 4/2025 under section 74/75 bracket 2 of the BNS 2023 read with section 8/12 of POCSO Act 2012. Issue notice,
To be, respond number 2, Lordship.
issue notice, full stop. The notice on respondent number 1 is dispensed with as MS L. Hage, Planet APP, enters appearance for the state. Notice on respondent number 2. Shall be Shah to the office of Planet PP. And the same will be and the same will be served on the informant victim, that is respondent number 2, to the officer in charge of the concerned police station.
Lordship,
CD
case
is-
diary, yes, Lordship. Updated
C-
case diary. The updated scan copy of case diary.
Updated scan copy of this
Case diary.
updated scan copy of the case diary is called for. Place the matter after 2 weeks.
That fixed that may be given.
Lordship, here, Lordship, if no one appearing on for the respond number 2, Lord, then LSC may be appointed because this is POCSO matter, Lordship.
Correct. So 2 weeks, I mean, service of notice will be required probably.
Lordship.
Huh?
One-
Is the matter after 2 weeks? After 2 weeks.
item number 2,
May I please, Lordship? This is an application under 528 of VNS. Lordship, at the outset, I would like to tell this court that the present case is
Speak louder.
purely a civil case, which has been colored as criminal in nature. Your Lordship, the complainant hearing is the political interpreter in the Office of the Deputy Commissioner. And the present FIR was aroused out of an alleged eviction operation, which was carried out in regard to the land which is in the possession of the petitioner, situated opposite to Department of Disaster Management, UPIA, which falls under UPIA Township area.
Where is the FIR?
FIR is annexure number 1, Lordship. Page number 15.
What is the type copy? You don't have a type copy of this?
My lord, may come to page 19, my lord.
Page number 19.
Who is this Nabang Talam?
Nabam Talam is the political interpreter in the office of,
He's a government servant.
yes.
So you have encroached upon government land and you have been
Lordship,
rightly evicted.
Lordship, it has been stated in the FIR that there was 2 eviction operation was conducted in the said land.
There was?
There was 2 eviction operation has been conducted in the said land.
Yes.
But there, I was never served any notice.
But you have
In regard-
but have not been served notice, but we have been evicted thrice. And we have reinforced the land 3 times. And
Lordship-
during that time we didn't ask for notice.
Lordship, at
there
the
was
time
no-
of the eviction,
On 25th February.
yes, Lordship, at that time also he was not present here. He was in Delhi. He was not present at the time of the eviction. And on the date,
He did not be present.
Lordship,
Anybody from his household can take
there was no one present in the place, Lordship. And Lordship, he was again served a notice from the estate officer, which has been given in
No,
Annexure
as far
number
as
3.
Eviction is concerned, that is not the issue. Correct. The issue is like that you have obstructed them. You have threatened them.
Lordship,
That is the offense.
in that regard, in that regard, your lordship, I was not present at the time of the eviction.
Which
Both time.
eviction? There are many evictions. Which time you were not there?
Both the evictions, your lordship. In both the eviction, he was not present.
How can you show that? That you were not there? And what is this gift deed?
Gift deed, he has acquired the land through this gift deed from Sri Nabam Dominic, who is an acknowledged landowner in the UPA township area. And there is no second order for second eviction order as well. Whereas, lordship, I was served as notice for the first eviction, but second eviction there was no notice was served, and then when he was given notice.
Yes, Mr. Ape, what do you
Yes,
want to say?
My lord, regarding the land dispute, whether it is government property or not, that is sub judice before the executive magistrate, before the estate officer. But so far as your lordship, the FIR is concerned, the allegation is regarding the commission of cognizable offense. When the person went there, he threatened him with any consequences, your lordship. So for that, your lordship, and he entered into the land. As on that, your lordship, he do not possess any document as such to show that the land has allotted to him, my lord.
So we'll issue notice.
Yes, issue notice, my lord, and call for the, my lord, case diary, your lordship. And your lordship, the second part is, my lord, the FIR is lodged by Mr. Navam Taling. Although he has been deputed as a PI for eviction, but he is the necessary party here also, your lordship, because since it is for quashing of the FIR, my lord, so he must be given an opportunity. So however, your lordship, he has not been implicated in this case.
The informant is a necessary party.
Yes, your lordship.
Lordship, FIR has already been registered once. So the FIR is lodged, and then the matter is between the state and the accused person. So in my understanding, the complainant is not a necessary party in this case.
Here, your lordship, the land at least purportedly belongs to your lordship, the state government, your lordship. And this person has been deputed by the,
Now, Mr. Ape, now since this FIR is filed,
yes, your lordship.
since, he may not be required. He may be required in the other proceeding for evidence. But
Yes, Your
as far as this matter is concerned, I don't think he's not even.
I believe it, your lordship, yeah.
Yeah, because now it has, since FIR is filed, the case will proceed. And if anything is required in the trial court, then trial court will see whether whom to be called in the
Yeah,
proceeding.
your lordship.
But at this stage here, I don't think we can make this heard MS so and so. Also heard Mr. TVK, learned DPP for the state. This is an application under section 528 of the Bharatiya Nagarik Electra Samhita 2023 for quashing and setting aside of FIR dated 1/7/2025 in Demo PS case number 91-20525 registered under section 329 bracket 3 stroke 224 stroke 351 bracket 3 of VNS 2023. Issue notice returnable in 4 weeks. Notice on respondent number 1 is dispensed with as Mr. T. Yadu, learned APP appears on behalf of the state. Registry may call for the case diary. Scan copy, update it. Update it.
My lord, it may be through us, your lordship. The investigation is pending, my lord.
Learned APP may submit a scan copy of the case diary on the next date of listing. List is matter of the 4 weeks.
Obliged.
Obliged.
Item number 3.
May I please, ma'am?
My lord, this application is for quashing of FIR and the subsequent charge sheet arising out of the Women Police Station, Itanagar, and now which is pending before the Chief Judicial Magistrate, UPA. My lord, this is a classic case where the criminal law machinery has been grossly violated, grossly misused, and an innocent person has been falsely implicated in this case, my lord. In this case, the FIR was filed in the year 2025, and the allegation is of 2023. After a gap of 3 years, the FIR has been filed. The foundation upon which this whole case is structured, madam.
So we'll issue notice.
I'm seeking for a stay of this.
Stay now.
Yes.
I'll go through this.
Well.
We'll only, we'll call for the case diary. Let's see, maybe it's an old matter. The case diary has to be seen what is there and not there.
Lordship, here, the victim was not made party, Lordship. So her participation right is also, Lordship.
Who is the victim? What is the affair?
Complainant, Lordship.
What is the affair?
FIR is, Lordship.
Complainant by whom?
The victim, Lordship.
Yes.
Is it page number, Lordship? The 30 onward, Lordship.
My lord, that may not be required since the rule says otherwise, my lord.
See, will be a necessary party in this case.
My lord, so far our rules are concerned, my lord,
What rules?
Guwahati High Court rules.
Show me
my
what
lord,
rule,
have-
under what rule you were exempted from making the victim
Well.
informant a party?
Otherwise, we had a notification wherein the cases where the victims are of POXO or the 376 AB gang rape.
That is different.
Different issue.
POXO, that will be specifically stated that
Yes,
we'll have to make party.
But in this case,
Hmm.
so far the rules are concerned. It's
Which
not
rule,
mandatory.
which rule?
My lord, may kindly read the notification number.
A notification of which number? So, 3, 4, 5, 6, which one?
First one.
1A, yes. It is not obligate.
Victim or the accused person, as the case may be, as respondent in the appeal filed under 378 of the Code of Criminal Procedure or under proviso to section 372 of the Code, and also in the revision petition under 397/401 or in a petition filed under 482 of the Code of Criminal Procedure. So in compliance of the rules, my lord, I have not implemented the victim as a party. Otherwise, my lord, if my
This is the latest rule.
latest rule, my lord.
But Lordship, I have authority, Lordship, wherein the Allahabad full bench held that, Lordship, the person who is entitled to be heard should be given opportunity, Lordship. Opportunity given to the person who is entitled to be heard. Lordship.
But the rule says it is not required.
But otherwise also in his petition also, Lordship, he stated that some money was deposited in the account of this victim, Lordship.
But those allegations are there. We are
Yes,
into the issue of whether she should be made a party or not. So rule specifically says you have given him a copy. Give him a copy. Now what is that?
Lordship, Allahabad judgment, technical note.
What does it say? Then our High Court, see, this is regarding our High Court, right? Our High Court says, you go to the, it says that it is not required.
Yes, Lordship. But participatory right is there, Lordship.
See, out there, there was a case where in the Sessions Court, she was never not given the opportunity. See, it says that conclusion which is arrived, the para you have referred to, indisputably a valuable right accrued to the appellants by reason of order passed by the Sessions Court refusing to issue summons on the ground that no prima facie case has been made out on the basis of evidence brought on record. As discussed here, when the Sessions Court order has been challenged, then it was incumbent upon the Divisional Court to give notice an opportunity of hearing as contemplated under subsection 2 of section 401 of CRPC. In our considered opinion, there is no reason why the same principle should not be applied in a case where such orders are challenged in the High Court under section 482 of CRPC. There the factual thing was little bit different. Someone was not issued, then against that they have come to the court.
Yes,
Then
but
the court felt that the person should be heard.
yes, Lordship.
So accordingly, the opportunity was given.
Yes,
But our High Court specifically says this. Now, what is 401? Let us see what is
Revision.
401.
Revision.
The principle underlying now.
370 is appealed by the state and 372 is appealed against acquittal.
The principle underlying 4012. Here 401 says no order under this section shall be made to the prejudice of the accused or other person unless he had an opportunity of being heard. Or what prejudice will be caused to him? Caused to her?
Since she is the victim and the informant, Lordship, if without giving her opportunity, Lordship, Lordship.
But the High Court rule says otherwise.
My lord is not invoking the jurisdiction of 401. We are under 528, my lord.
Yes,
For-
it's
for it.
ignorant jurisdiction.
Even otherwise, my lord, if my lord allows me only 2 minutes of time, I can demonstrate from the record that she has made a false narrative to falsely implicate
But
me in the
that
case,
is-
my lord.
That is on the merit. At this
My lord.
stage, I don't want to hear that. But only thing is that I'm concerned with whether informant should be in the party or not, because it's a case of molestation,
My lord.
a serious offense.
But she has been lying throughout the investigation, my lord. I can demonstrate from the record itself. If even my lord may kindly have
That is again on the merit.
my
That
lord,
is again on the merit.
my lord.
That is
In
again
this
on the
case,
merit.
in the case, lordship, notice may be on issue.
We'll issue notice
Yes,
and then
that
we'll
was-
keep, you can raise an objection by the later stage.
So far as the participatory right, my lord, is concerned, the rule cannot take away that participatory right, which has been declared in Jagdish Singh matter, my lord. Even if implement is not there, notice can be issued, my lord. In Pratik Jain case by our own High Court, your lordship, considering the Jagdish Singh matter, because your lordship, this notification has been modified after coming into the.
That depends on the facts of the each and every. case.
Exactly, my lord. Here
and
is a
every
case of molestation, my lord, where your lordship, the victim, in fact, your lordship will find in 1673 of the earlier CRPC also, when investigation is once completed, my lord, the victim, the first person who has given the information must be informed about the status of the case. That means CRPC recognized. And later on, your lordship, in Jagdish Singh matter, my lord, the participatory right has been declared by the Honorable Apex Court. Wherein, however, your lordship, the impleadment part was not there, whether he has to be impleaded or not. But participatory right has been declared by the FX court, my lord.
So participatory right is there means like you'll have to implement him only otherwise.
Yes, your lordship. And your lordship will
See,
also, your lordship will also find in 439 subsection 1A, capital A, wherein your lordship, by the way, the Mutati Mutandis of the Delhi High Court judgment, my lord.
And let us do one thing,
Yes.
straight like at this stage, I will issue notice. I will not, I will record it that an objection has been raised by the PP
Yes, your lord.
as far as not making this victim informant
Yes,
as a party. And that objection you can raise in the next case.
yes.
Then that can be
Otherwise, my lord, requirement of informing the complainant under 173 is in every case, my lord. But specifically there's a codified rules on this aspect.
So
That under
the-
482 is not
this
required.
issue, I will keep it open
Well, yeah.
because at this stage, I don't want to spend time on this.
My lord.
Let them file.
My lord, on notification, my lord, you'll find 372, my lord. It's an appeal against acquittal, my lord. The appeal against acquittal, the person who has been acquitted, he is the necessary party in the case. There it said is also not obligatory. Then
Unless and
the
until they,
notification is vague,
unless
my
and
lord.
until they challenge
So
the rule.
my
my lord.
humble submission, my lord. Because this
Still holds appeal.
that was modified by coming into the Jagdish Singh matter. Your lordship will find
Okay,
370.
we'll hear this. We'll hear on this.
Yes,
and
your
then on the next day.
Yes,
We'll just record it. We'll just issue notice now.
Yes,
And that point like that he has raised,
yes.
that we will record like, on the next day that can be heard properly. You know, the motion stage will not be anything.
Right.
Heard Mr. Heard Mrs. Srivastava, learned counsel for the petitioner, and also heard Mr. Lee Louis, learned PP for the state of Arunachal Pradesh. This is an application, instituted is an application under section 528 of BNSS 2023, praying for quashing and setting aside of the criminal proceeding emanating from Omen PS case number 02 of 2025, which is presently pending before the Honorable, before the learned Chief Judicial, before the Court of Learned Chief Judicial Magistrate UPIA, corresponding to GR case number 75/25, registered under section 69 of BNS 2023. Heard the parties, heard the learned counsel for the parties, learned PP has submitted that though the informant victim is a necessary party in the instant application, then the same has not been done. Therefore, he submits that the direction may be passed by this court to make her to include her in the instant petition. However, learned counsel for the petitioner has submitted that as per the relevant provision, that is 1A capital 1A chapter 11, Roman 11. Then criminal business, comma, A general provides that the proceeding under 528 it is not required to include the informant complaining victim as a party. At this stage, this court doesn't, this court is not applying to the issue raised. And the issue is that often to be raised, raised after raised on the returnable date.
My lord, a short date may be given, my lord, at least 2 weeks of time. Otherwise, my lord, the proceeding since the,
2 weeks, I mean, whether this will come, TCR will come, trial court records.
in UPI itself. Yeah.
UPI itself. Registry may call for the scan copies of the TCR. Let this matter be listed after 2 weeks.
Since the cognizance so far has not been taken in the trial court, till the next date, my lord, some. This may,
No, let it, I mean, see, I have kept this issue also
Otherwise, my
open,
lord,
so you can
I have a-
put it.
I have a very good case.
Without looking into TCR, at this stage, it will be.
My lord, some observation that the interim will be considered on the next date.
You can write an interim prayer made to this application shall be considered the next date of listing. Next, on the returnable date, like that. The issue regarding interim prayer made in this application will be considered on the returnable.
Grateful.
Item number 9.
On last term, CD was postponed.
Item number? CD is there?
Yes.
Yes.
Madam. This, accused person is, second rating.
Yeah.
Now she is in, critical phase,
See, accused person is
second rating.
apartheid.
No, madam,
Apartheid is the
say applicant and,
apartheid is the husband.
yes, husband.
Just tell me the facts of the case.
Your Lordship will find
Facts
that
of the
FIR
case.
it
Let him say.
So, madam, she, got,
Now, what was the offense he has committed?
madam, the offense was, murder.
Huh?
Alice offense was murder. Madam, kindly see page number 19.
Case number 19 is the affair.
Yes,
Hmm.
madam.
Yes.
Information regarding murder of late Honest Dole.
Hmm.
Sir, on dated 1/8/2025 at around 16:30 hours. 4 ladies namely Srimati Oyotai Moran, alias Pupun, who,
Okay, there is the case of that person who fell down
yes,
from there.
yes.
Is there anything in the case diary?
Your Lordship, no, the only status report at present is that there are some more witnesses to be examined. Other than that, there is nothing as such, Your Lordship. Because there are few independent witnesses at whose house the incident happened, Your Lordship. Some of them did not see the scuffle. They knew that there was a scuffle. There is one person at the statement at page number 21, Your Lordship. It's
21 in the case diary.
case diary, Your Lordship.
Statement of Silip Pao or something.
Yes. And page number 25 is
He is also witness.
yes, he's not a witness to the scuffle, but then when the deceased died.
Yeah.
There is nothing as such that any of the specific eyewitness stated that they have killed it. They state to the fact that there was a
There was
scuffle.
some scuffle happened and there may be a fall and he was an old person. So he expired.
Other than that, there is nothing as such in the case diary not present. Also considering that your lordship has on the last occasion called for the medical report, your lordship. However, the registry could not get the same, your lordship. From
The
the
medical report may not be necessary at this stage.
leave it to your lordship discretion because as per my
You are objecting to
submission,
it. Or?
no, I'm not objecting as such.
Then where is the statement of this Prabhadai type?
Your lordship.
This house supposed to be the eyewitness.
Yes, it's there, your lordship.
It's there in the petition.
It's there in the case diary.
Case diary.
I'll just get the page.
Yes. Okay, I'll record the submissions, yeah, and I'll record that like you don't have,
Any-
after going through the case there, you have not objected. Then I'll allow this. These four are same?
Yes.
I'll keeping the case there.
Keep.
I'll pass the order. In four, all these four cases, right?
Yes.
So I allow this with some conditions. And yes, and with all these four cases, I'll allow it. The order will be passed.
Item number 13.
Lordship, this is
Uh,
criminal.
there is a office note that says that Wakalatnama has not been filed. D. Ado, who is D. Ado?
Yes, on last occasion they appeared.
He appeared, but Wakalatnama hasn't been filed.
Yes, Lordship, actually they
No,
appeared.
without the Wakalatnama, how can you appear?
Actually, there are numbers of cases, parallel cases are going on
No, no,
before.
you're filing Wakalatnama.
No, I'm on behalf of this petitioner for department
Huh.
for CGST.
Okay.
So
Who is Mr. D. Ado?
D. Ado is a respondent.
That's what I was asking. I thought you are D. Ado.
No, Lordship.
I was asking whether you are D. Ado.
Actually,
He said
they-
yes.
I think Dolan is there in court number 2. Then it may
He is Mr. Ado. You haven't filed a Wakalatnama as a.
Yes, Lordship. That is coming tomorrow, Lordship, from Calcutta.
So you filed a Wakalatnama. You filed a Wakalatnama. Okay, without Wakalatnama, how can you appear?
Yes.
Uh, Mr. So and so, your name please?
T. Kipa, Tanya Kipa,
Mr. Tanya Kipe appears on behalf of
CGST.
CGSC for whom?
Uh,
Respondent number?
Yeah, no, not for respondent. I am a petitioner.
For the petitioner.
Yes,
One second.
that's petitioner is IO of this case.
Saurabh Pandey,
Yes, Lordship.
Inspector. Okay, this is Mr. So and so appears for the applicant.
One, two.
Mr. Ginny is appearing.
Oh, three, your lordship.
MS Ginny appearing for respondent number,
Three, your lordship.
respondent number 3. There is no 4, only 3.
Only three, your.
Respondent number 3. Whereas Mr. D. Ado,
K. Lolan.
Huh?
K. Lolan.
K. Lolan. Your name is K. Lolan or D. Ado?
K. Lolan.
No, someone,
Is my assistant.
the last time that Mr. D. Ado says that he has appeared and he will file a petition, Wakalatnama.
Yes.
Mr. K. Lolan, Planet Council, appearing before this court, submits that he has been instructed to appear in the matter for respondent number 1 and 2. However, the Wakalatnama is yet to be received by him from the respondent number 1 and 2. Therefore, he pays a week's time to file the Wakalatnama on behalf of respondent number 1 and 2. Prayer is allowed. Please, this matter
Lo-
after a week.
Lordship, yes, because this bail cancellation application has been pending for last around 5 months, and the investigation is now stuck because of non-compliance of those alleged accused.
So
So,
if you file the Wakalatnama next week, you can argue, I mean, then you can argue.
so,
this.
so next
So next
for
week-
admission hearing maybe.
Within next week,
Yes,
within a week, you file.
admission hearing.
And let the matter, but thing is that if he doesn't file, let the matter be listed in the admission column.
Yes, Lordship, actually
Ah.
that has been routed to.
The copies of this memo of appeal shall be served on the council for respondent number 1 and 2 once the Wakalatnama is done.
Yes.
We have not filed a we filed a Wakalatnama, then he'll serve the copy. Yes.
Item number 14,
Please the matter after week.
Here the service to the victim's families is still awaited.
PCR is not received as yet.
Yes, also the service upon respondent number 2 is awaited. Your
Your Lordship, I may be given liberty to take service again, Your Lordship.
Press service.
Actually,
Mr.
Your Lordship, problem regarding their address, the victim's family.
Hmm?
There was a problem regarding the address of the
Mr. So and
victim.
so appears on behalf of the petitioner. On
Appellant.
behalf of the appellant, and he submits that PCR in the case is yet to be received. He further submits that further submits that service of notice, report on service of notice on respondent number
2. Your
respondent number 2 is yet to be received. He prays for taking fresh steps on respondent number 2. The prayer is allowed. Let the council for the respondent number let the council for the appellant take fresh steps on respondent number 2. Registry may send a reminder to the concerned. Which court is this?
Pasigat, District and Session Court, Pasigat, Your Lordship.
Reminder to District and Sessions Court, Pasigat, to send the PCR at the earliest. Release this matter after 3 weeks. 3 weeks.
Obliged, Your Lordship.
item number 16,
Yes,
Lordship, I am for the petitioner.
yes,
I am for the petitioner.
you are for the petitioner.
Yes, Lordship.
Who is for the respondent? The MSC case, civil revision.
Yes, Lordship.
Who was appearing in the matter?
Lordship. Boloram Das.
But affidavit in opposition as in a Wakalatnama filed by Learned Council behalf of the state respondent. How many respondents are there? Private respondent is there?
One, Your Honor. One respondent.
You are appearing for whom? You are appearing for the SDFC.
In 3 years, Lordship.
And the private respondent submitted Thapa. How can the affidavit in opposition as well as Wakalatnama filed by Learned Council on behalf of the state respondent? State is not a party. It's a sole respondent. Sole respondent. She has filed an affidavit. And somebody was appearing also. Okay, right. Mr. So and so, Learned Standing Council for the SDFC, for the SDFC, ERGOGEN.INS co company co Ltd. appears for the petitioner. Appears for the petitioner. However, none appears on call for the sole respondent. Though an affidavit is found on record, and though an affidavit filed by the respondent is found on record, for the ends of justice, let this matter be listed after 2 weeks.
Hello. Item number 18.
None appears.
Lordship, I'm for the state.
Huh?
I'm for the state. Lordship.
None appears for the petitioner on call. However, MSL Hage appearing for the state of Himachal Pradesh. This is a book. Okay. And Hage APP appears for the respondent state. List this matter after 2 weeks. Okay.
Item number 21.
Yes. Service report still awaited.
Report is awaited.
Mr. So and so appears for the petitioner, and MST Zini APP appears for the respondent state. Seen the office note dated 25/8/2025. Service, as per the note, service report is still awaited. List this matter of 2 weeks.
Thank you.
Please finish. আগতে এটা মাটি ছুটি করতাম পরে লাস্ট মিনিট ওয়াইজ তুমি আগে তোমার